Good Vach, Shavua Tov. How's everybody doing? Wishing you a good week, and we're starting it off with some beautiful Torah learning on a Saturday night. Let's light up the darkness. A new wisdom candle. Who's in the house on a Saturday night? Joe in the Inland Empire, Karen in Northern California, Shandora in the Bronx, Bella in Florida, John in Maine, Ella's with us, Chaim in Florida, Marie in Freeport, New York. We are continuing our discussion of Mishna number 4 here in chapter 3 of Tractate Bava Basra, the 23rd volume of the Talmud. Mishna number 4 held that certain people cannot establish a chazaka of ownership, a presumption of ownership, just because they've been using a property, residing on a property, taking benefit from a farm, field, vineyard, orchard, etc., or it's a movable property, but they cannot establish the presumption of ownership even though it's been in their possession for more than the requisite 3 years, because they had some other reason to be present on that property or using that property rather than owning it. For example, a sharecropper or partners or a craftsman who is given an item to fix. Well, there's the old joke of in the Soviet Union, a guy brings his shoes into the shoe repair craftsman, and he says, when will the shoes be ready? And the guy says, 10 years. 10 years from today? 10 years from today. Yeah, that's no good. I've got the plumber coming. That's a Soviet Union joke. But it might have been in his possession for 10 years. But it wasn't given to him to own. He didn't purchase the shoes. He wasn't gifted the shoes. They're in his possession because he is repairing the shoes. So a craftsman does not have a chazak of ownership after possessing something for 3 years. We also were talking about when somebody is an interested party, can his testimony combine with another witness to form a valid testimony, meaning the testimony of 2 witnesses, if he's an interested party. So you might think that if there were 2 partners owning a property and one of them sells his share to the other, okay, he is out of the picture. He no longer owns property. Why shouldn't he be able to join testimony with another witness who's aware that the partner bought him out, and then the 2 of them establish in court that that partner is now the sole owner of the property? Answer: because the one who's selling his share to this other guy might have creditors who are going to pursue this field now that it's been established. Okay, you no longer own it, but who owns it? Well, now you've just told me that your former partner owns it. And since you owe me money and you don't have property anymore, I can go pursue that property even though it's now owned by someone else, because in truth, Sal, you had no right to sell it. So even though I'm no longer an owner of that property, I do have a financial interest in it, and for that, because my creditor could pursue that property from the new owner, for that reason I am an interested party, and I cannot testify about it because I have a bias, an inherent bias. We pick this up near the top of page 43b, which is a short daf, and our daf tonight is page 44. The sages taught, if one sold a house to another, or if he sold a field to him, he cannot testify about it for the buyer against a claimant, because the financial responsibility to compensate the buyer for it is upon him, and his testimony is biased. Again, if I sell it to someone else and then there's a chance that it'll be repossessed from him because a creditor of mine is going to go get it because I owe him money, and I've given this buyer a guarantee that if it is repossessed from him, then I will make it good. Well, maybe I would prefer that he not have it so I don't have to pay that guarantee, or maybe I would prefer that he has it so I don't have to litigate with this guy. Either way, I'm still involved, and therefore my testimony will not be used in that matter. Now the Gemara asks, what is different in the first clause that he cannot testify? Well, I'm sorry, I didn't finish it. So if one sold a house to another, or if he sold a field to him, he cannot testify about it for the buyer against a claimant because the financial responsibility to compensate the buyer is upon him, and his testimony is biased, as I just said. By contrast, if he sold a cow to him, or if he sold a cloak to him, he can testify about it for the buyer because the financial responsibility to compensate the buyer for it is not upon him, right? We issue a guarantee on a purchase that it wasn't lien for something else. That applies to real property. We're not going to apply that same kind of real property guarantee to movable property like a cow or a cloak. But the Gemara asks, what is different in the first clause that he cannot testify, and what is different in the latter clause that he can? Why would one assume that in the first case he does bear responsibility, but not in the second? Meaning, why can't you issue a guarantee on a purchase and sale of movable property? And Rav Sheshes said the first clause is stated with regard to the case of Reuven, who robbed Shimon of a field and sold it to Levi. Okay, Reuven is a robber, and he robbed a field that was owned by Shimon. What does it mean he robbed it? It means that without Shimon's knowledge, Reuven pretended to be the owner, and he sold it to Levi. Okay, Reuven robbed, Shimon is the actual owner, Reuven sold it to Levi. And then Yehuda comes and contests Levi's ownership, stating that it was actually his, meaning Yehuda must have bought it from Shimon, and he's the real owner. Reuven pretended to be the owner and sold it to Levi. So now Yehuda is making a claim against Levi that the field is actually his, right? Yehuda is coming to claim that it is his. So this Baraisa teaches that Shimon, the original owner, cannot go to court to testify for Levi because it is preferable for Shimon that the field be returned to Levi so that he can later collect it from him. Now this is very interesting. Shimon sold it to Yehuda, and he knows that. Yehuda is the actual owner. Reuven the robber sold it to Levi. But it might turn out that it benefits Shimon to say, well, yeah, you know what? It's better if Levi ends up with the property because I can go get it back from him. This guy Yehuda, he's rich, he's got big lawyers. Yeah, I sold it to him, but maybe there was a gray area. Maybe Reuven, it was not that he was just an outright robber, but he and I had a litigation some years ago and the outcome wasn't clear. He thought he owned it. I thought I owned it. I sold it to Levi. Reuven sold it to Yehuda. Now Yehuda's suing Levi. You know what? Benefits Shimon that Levi ends up with the field because after that, he'll be able to sue and get it back for himself. Whereas if it ends up with Yehuda, he won't. So, can he testify for Levi that Levi bought it from Reuven? Answer, no, because Shimon has a vested interest in the outcome of that litigation, and therefore he's biased, and therefore he can't testify. The Gemara asks, but once he testified that the field is Levi's, how would he be able later to remove it from his possession? What are you saying, that he could later come and say it'll be easier to enter litigation with Levi and extract it from Levi because Levi's poor and doesn't have big lawyers the way that Yehuda does? But if he said that the field belongs to Levi, how could he later come and say, no, actually belongs to me, when earlier I testified against Levi, I don't know what. That doesn't make sense, is what the Gemara is saying. But the Gemara answers, no, it's like this. This is referring to a case where Shimon says in his testimony, I know that this land is not Yehuda's, but he did not explicitly testify that it belonged to Levi. He is therefore able to later claim it is his and not Levi's, and that's why we don't let him testify in the first place. Now the Gemara asks, but why should he testify that it does not belong to Yehuda with that same right by which he removes the land from the possession of Levi? Let him remove it from the possession of Yehuda. It is not to his advantage to lie in order to establish it in the possession of Levi, and his testimony should not be considered biased. And the Gemara answers, because Shimon says to himself, the second person is amenable to me while the first is more difficult than he is, i.e. I prefer to litigate with Levi than with Yehuda, which is what I was saying earlier. And if you wish, say instead that the case we're referring to, where you are going to assume biased testimony in a case of land, but perhaps not in a cow or a cloak, it is referring to a case where the master, Shimon, has witnesses attesting to his ownership, and the other master, Yehuda, also has witnesses attesting to his ownership. And the sages said that under such circumstances, the land should remain where it is. That is to say, it should remain with the one currently in possession. We have two sets of valid testimony in the sense that each is bringing two witnesses who have not, been shown in some other time to be dishonest. So we've got two honest witnesses on this side, two honest witnesses on that side. Their testimony is contradictory. So what are we going to do? We're going to leave the land where it is, i.e. in the possession of whoever has it now. So if Yehuda were to be awarded the land, Shimon would not be able to remove the land from his possession despite having witnesses to support his claim, as Yehuda also has witnesses supporting his claim, and he would be in possession of the land. And so as a result of Shimon's testimony, the land will be awarded to Levi, who has possession as a result of his purchase from Reuven. Then Shimon will be able to remove the land from Levi's possession by proving that Reuven stole it from him. Therefore, Shimon's testimony is biased. In other words, simple explanation would be if somebody has a situation where it looks like he's disinterested, but we can see a path where he could use the legal system to his advantage, and therefore he does have a vested interest, well, then he's biased, and we don't let him testify. We don't count his testimony as one of the witnesses. Now we're on page 44a. Now the Gemara asks, and according to the understanding of Rav Sheshis, that the Baraisa is disqualifying one whose field was stolen from testifying on behalf of one who purchased the field from the robber, why is it necessary to discuss a case involving a buyer when it would be simpler to establish it with regard to testifying for the robber himself? And the Gemara answers that the Tana of the Baraisa, the rabbi of the Mishnaic period, who authored this Baraisa, which is a contemporary of the Mishna, but not quite as authoritative. So the Tana of the Baraisa discusses a case involving a buyer because he wants to teach the latter clause when he gets to the movable property, the cow or the cloak. If he sold the cow to him or if he sold the cloak to him, he can testify about it for the buyer. As in this clause, the Tana specifically needs to discuss a case where the robber sold it, because then it is a case of despair by the owners due to the robbery. Right? Once the owners despair of ever recovering the property essentially becomes ownerless and now is in the possession, becomes the property of the one in whose possession it is. The robbery caused that. And there is also a change in possession due to the sale, right? The robber sold it. Since the original owner despaired of recovering it, the one who bought it from the robber does have possession of it. He is therefore no longer biased in his testimony, and he can testify for the one who purchased the item. But in the latter clause, if the robber did not sell it, in which case the stolen item is returned to the robbery victim, then he cannot testify, as he prefers that the item be in the possession of the robber so that he can recover it from him. Therefore, the Tana taught in the first clause as well about a case where he sold it so that the cases would be parallel, right? The sale changes the situation to where you could, identify that in that situation, the guy could testify because he really has no interest in it anymore. Since it was stolen from him, it was robbed from him, he despaired of recovering it. Then he saw that it was sold to somebody else. He's not going to recover it anyway. There's other nuances of that. But the point is, he doesn't have the kind of bias that he would if he could testify that it wasn't a sale, it's still in the possession of the robber. He hasn't despaired, and he can get it back from the robber. Now, the Gemara asks, and in the latter clause as well, where there is despair and change in possession, granted that he despairs of recovering the item itself, but did he despair of being reimbursed for its value? While it is true that he lost his ownership of the item, he is still entitled to be paid. Therefore, to be compensated. Therefore, he is still biased in his testimony. And the Gemara answers, no. It is necessary in a case where the robber died, in which case the robbery victim cannot collect even the value of the stolen item and is no longer biased in his testimony. As we learned in a Mishna, Bava 111b, in the case of one who robs another of food and feeds it to his own children, or who left a stolen item to them as an inheritance, the children are exempt from paying the victim of the robbery after their father's death. Since he is no longer able to collect the value of the stolen item, he is not biased in his testimony, and he can testify on behalf of the buyer. Now the Gemara asks, and why not establish the entire Baraisa with regard to testifying for the robber's heir? This would demonstrate the contrast that the Tana wanted to teach. In the case of a stolen field, which always must be returned to its owner, the robbery victim, there's no despair of recovering a field. The robbery victim is biased in his testimony because the field can be recovered. Therefore, it is in his interest to establish that it is in the possession of the robber's heirs. In the case of movable property, which cannot be recovered after the death of the robber, he is not biased in his testimony. And the Gemara notes, this works out well according to the one who says that the transfer of an item to the possession of an heir is not like the transfer of an item to the possession of a buyer, but is viewed as an extension of the possession of the ancestor who died and left property to his heir. Right, that's an extension of his property as opposed to the change of possession that happens on a purchase and sale. So according to this opinion, it is well that the Baraisa did not establish its case with regard to the robber's heir, as the robbery victim would be able to recover the item and would be considered biased in his testimony. But according to the one who says that the transfer of an item to the possession of an heir is like the transfer of an item to the possession of a buyer, and the item is therefore not recoverable in either case, then what can be said to explain why the Baraisa does not state its case with regard to an heir? And furthermore, this explanation was difficult for Abaye to understand, as according to Rav Shesh's explanation, is it accurate to state, as the Baraisa does, that the distinction exists between the cases of land and movable property? Because in the first clause, the financial responsibility to compensate the buyer for the land is upon him, and in the latter clause, the financial responsibility to compensate the buyer for the movable property is not upon him? That is not the crucial distinction. The Tana should have taught instead that the difference is, here he cannot testify because the stolen field returns to him. And here he can testify because the stolen item does not return to him, right? One causes bias, the other doesn't. So the Gemara offers a new explanation of the Baraisa, meaning how the Baraisa was designed in order to teach its principle. So rather, explain instead in accordance with the statement of Ravin Bar Shmuel, as Ravin Bar Shmuel says in the name of Shmuel, one who sells a field to another, even without a guarantee, that if the field will be repossessed, the seller will compensate the buyer for his loss, cannot testify with regard to ownership of that field on behalf of the buyer because he is establishing the field before his creditor. And the Gemara clarifies this by noting, and this is the case specifically in the case of a house or a field, but in the case of a cow or a cloak, he is not biased in his testimony and he can testify on behalf of the buyer. And the Gemara explains it is not necessary to say that this is the law in a case where he sold a cow or a cloak without specification, where it is not liened to the creditor, right? No L-I-E-N, lien. What is the reason for this? It is because these items are movable property, and movable property is not liened to a creditor. And even though it is so that the debtor wrote to the creditor that he can collect the debt, even from the cloak that is on his shoulders, that matter applies only when it is as is and in the possession of the debtor. But if it is not as is, since it is no longer in the possession of the debtor, since it is now in the possession of the buyer, then no, the creditor cannot collect from movable property. Therefore, the debtor can testify on behalf of the buyer. Now we're on page 44b. Again, bottom line. Does the one who's being asked to testify have a financial interest in the outcome? If yes, he may not testify. If no, he may testify. Now the Gemara continues, but even in a case where he set the cow or the cloak aside as designated repayment, apoteki, the creditor cannot collect from it. Now, why is that? We said in this case, well, there's a lien on land that, if he testifies for the buyer, it's going to change his situation. He may benefit from that. But there's no lien on a cloak or a cow. Well, what if you say that, yes, this cloak or this cow is the collateral for a loan that I'm extending? Then doesn't that create the same situation as a guarantee or a lien on real property? So what is the reasoning? It is in accordance with the statement of Rava. As Rava says, if a master set aside his slave as designated repayment of a debt, and then he sold the slave, the master's creditor collects the debt from the proceeds from the sale of the slave. But if one set aside his ox or his donkey as designated repayment and then sold it, the creditor does not collect the debt from the proceeds of the sale of the ox or the donkey. Now there we're seeing, as it was in the ancient world when slavery was sadly practiced, that slaves were compared to real property, and livestock was not. Now what is the reason for this distinction? This setting aside of the slave as designated repayment generates publicity, and that setting aside of the ox or donkey as designated repayment does not generate publicity. In other words, the buyer of the ox or the donkey has no reason to know that that animal is being used as collateral for a loan that the seller has with some other creditor. But when somebody pledges a slave as collateral for a loan, somehow that's going to be more widely known in the community when slavery was practiced. Therefore, when the slave had been set aside as designated repayment, the buyer would have been aware of this. Since he bought the slave while having this knowledge, the slave can be seized from him by the seller's creditor. By contrast, the buyer of the cow or the cloak would not have been aware that it had been set aside as designated repayment, so the seller's creditor cannot seize it from him. Now the Gemara asks, but let there be a concern that perhaps the debtor transferred the movable property to the creditor, not for him to own, but for him to have a lien on the movable property by means of, i.e., together with, an acquisition of land. Right? You can have a guarantee or a lien on land, not on movable property, but if the movable property is sold with the land, then perhaps the lien can be extended to cover the movable property as well. Then the creditor acquires the land and acquires the movable property together. Therefore, the lien is created with regard to both the land and the movable property. And Rav Chisda said, and that is the law only where the debtor wrote to the creditor, this lien is not like a transaction with inconclusive consent, kasmachta, which does not affect acquisition, and it is not like the template, ketofesa, for documents which are not actually used to collect debts. Rather, it is a legally binding document, right? The parties agreed that both the land and the movable property would have a lien on them to collateralize the loan. So the Gemara says, with what are we dealing here? We are dealing with a case where the debtor had purchased the movable property and immediately sold it, and there was no opportunity for him to have become liened, for it to have become lien to a creditor. Therefore, there is no possibility of his being biased in his testimony due to a desire to repay his debt. And the Gemara asks, but let there be a concern that perhaps it is a case in which the debtor wrote to the creditor, I will repay you even from that which I will acquire in the future, which would presumably mean that the creditor can collect from the buyer even though the debtor purchased the item after taking the loan. From the fact that this is not a concern, do you learn from it that even if the debtor wrote, I will repay you from that which I will acquire in the future, and he then purchased and sold property or purchased and bequeathed that property, that which he purchases is not lien to his creditor? This would seem to settle what is otherwise assumed to be an unresolved question, and the Gemara rejects this proof. No, one need not reach that conclusion. as it is necessary to teach the halacha, the law, in a case where witnesses say, we know about this one who sold these items that he never had any land. Therefore, it cannot be that the creditor acquired a lien on the movable property by means of an acquisition of land. And the Gemara asks, but doesn't Rav Papa say that even though the sages said, in the case of one who sells a field to another without a guarantee, and a creditor came and repossessed it, the buyer cannot return to the seller, i.e. to the debtor who sold him the field, to claim reimbursement. But if it is found that the field was not the seller's field in the first place, then the buyer can return to the seller to claim reimbursement. In this case, if the claimant establishes that the cow or the cloak is his and was not the seller's, the buyer will be able to claim reimbursement. The seller is therefore biased in his testimony and should not be able to testify on behalf of the buyer. I'm very close to done. Questions or comments, please get them in now. And the Gemara answers with, what are we dealing here? We're dealing with a case where the buyer admits that he recognizes that this is the offspring of the seller's donkey and will not claim in court that the seller had no right to sell it. And the Gemara returns to the statement of Rav Papa and comments, but in contrast to the opinion of Rav Papa, Rav Zevid says, even if it is found that the field was not the seller's, the buyer cannot return to the seller to claim reimbursement, as the seller can say to the buyer, it is for this reason that I sold it to you without a guarantee, i.e. so that if it is taken from you, I will not bear liability. Okay, so we really got into the weeds there on who can issue a guarantee, when is a lien assumed to exist, when is it not, do we apply a lien to a slave, to a cow, the way we would to land, what if somebody bought movable property along with real property and then sold it all right away but had another outstanding loan, etc. And these are all actually issues beyond the scope of what we were talking about tonight. We started by talking about who establishes a presumption of ownership. That's what the Mishna was about. That led us to talk about can a seller testify on behalf of a buyer after he sold out? Let's say, they were partners in a piece of land and he sold his half. And then the buyer asked him to testify in court that indeed he's now the full owner because his former partner sold him his half. The problem being that testimony might be biased because the seller would actually benefit from establishing the land that he sold in the ownership now, the full ownership of his former partner, because he might have an actual financial benefit from that testimony. His testimony is discredited or is not accepted. And therefore, then we saw that the sages tried to set up, sort of more and more complex situations where we question, does he have a financial benefit or not, given the way that the debtor-creditor law is working, or buyer and seller law is working, and how they intersect. The question they just kept asking is, does this seller of a piece of property now to the buyer still have a financial interest in it or not? If yes, he cannot testify that he sold it to the buyer to help establish that matter in court. If he has no financial interest of any kind in the outcome of that question, then he can testify. And then somebody just asked one little silly question: can our eyes count as two witnesses? And of course the answer is no, but a one-eyed man can count as a full witness. That's what I've got for us tonight. And with God's help, we'll be together again tomorrow, Sunday, at the regular Sunday time, 6 p.m. Pacific. Have a good night.